Good afternoon and welcome to this installment of Epic Insight. This is Brian Lenz, Director of Sales and Strategic Partnerships here at Epic, and I'll be your host again for today's call. With the recent release of the new DOL fiduciary rule, the retirement industry has been keeping an ear open and an eyebrow raised regarding what effect it will ultimately have on the retirement plan landscape. As we wait for the new rule to take effect and as experts weigh in, we thought this would be a good time to circle back and actually revisit some of the current DOL and IRS hot buttons. With all of the current buzz, it's really easy to overlook what is already law and already very enforceable. So with that in mind, we're pleased to be joined today by Rob Duffy, Vice President and Senior Retirement Consultant for OppenheimerFunds. As a senior retirement consultant for Oppenheimer, Rob collaborates with financial professionals to help find innovative solutions to retirement plan challenges and help grow advisors' books of business and meet investments needs in an increasingly complex retirement plan market. He directly supports advisors and financial institutions in the field and shares his technical knowledge and translates that into practical, actionable strategies. So you will be muted throughout the call today, but certainly if you have any questions you'd like us to address at the conclusion of the session, please enter those in the GoToWebinar questions panel. Without further ado, we'll turn it over to Rob Duffy at Oppenheimer to take it away.
Great. Thanks, Brian. Good afternoon, all. As Brian mentioned, the DOL has been busy as of late. Our entire industry has been keeping a close eye on them for the past year or so as it relates to their new fiduciary proposal. And as Brian also mentioned, now that we've seen it within the past couple of weeks, we're all busy digesting that and planning for the year ahead before it takes effect next year. But despite all of the time and effort they've been spending there, they have been active as it relates to their enforcement efforts. And we had built this presentation really with the goal of helping to better inform advisors, consultants, plan sponsors to exactly what it is that's going on out there on both the Department of Labor and the IRS's side, where they are having success with their enforcement activities and recovering plan assets. But both parties, interestingly enough, publish a lot of what they're doing, and their goal is to really create a more informed user, a more informed consumer as it relates to a plan sponsor, so that we all can learn from the mistakes and mishaps of others, and ultimately, I suppose, one day maybe put them out of work because there will be less to regulate and less issues to find and solve. So we can hope that maybe we get there one day. But interestingly enough, anytime a benefit is created, and this time in the sense of a qualified plan, with that comes a lot of responsibility in terms of oversight and fiduciary duty. And that can be a sizable task in some cases for a plan sponsor, depending on the size and scope and scale of a business when they decide to offer a benefit. So the other goal of this presentation today is to help all of you better inform clients and plan sponsors so that we can hopefully make their lives a little bit easier as well. We have a fairly aggressive agenda I would like to get through today. Technology cooperates here, we'll advance. So the next half hour or so, we're going to run through these items and then leave some time for Q&A towards the end. So I'd like to start by providing just a little bit of a backdrop on the regulators, both IRS and DOL. We'll jump into what we are calling kind of these hot buttons. Where are they publishing their thoughts and findings, and where are they finding issues within the businesses that they're investigating and auditing? And ultimately, we will then transition to how do we all use that to better serve our plans, or if we're advisors and consultants, better serve our clients, so that, again, we can learn from the issues that they've found through their investigations and their efforts. So we will jump right in. The backdrop that I mentioned that I like to set from the start of, just to kind of remind people, not that you need reminding, but that these two bodies are out there, and while they're very similar, there are slight differences in what they focus and where they look. So when Congress writes laws to enact qualified plans such as 401ks, they look at these two guys, Department of Labor and the IRS, for guidance in creating those laws, but then they also task them with the responsibility of going out with the enforcement effort to go enforce the rules that you've helped us write in all of this. So kind of on the left-hand side of the screen, we have the Department of Labor, and these guys are really the ERISA, the fiduciary guys. So when you see their publications and where they spend their time and effort, it's very much through that fiduciary lens. So it would come as no surprise that this new fiduciary rule just came out of the Department of Labor. And they very much want to make sure that virtually all the activities of a plan sponsor are being done in the best interests of plan participants and plan beneficiaries, that they're following the terms of ERISA and following the terms of their plan documents. And their actions have been successful. They publish each year how much money they've recovered on the parts of plan participants and plan beneficiaries, the number of investigations that they've conducted. And so they've been active for the past several years. Looking at 2000 or fiscal year 2013, they recovered approximately $1.6 billion on the behalf of participants and beneficiaries, and that came from conducting about 3,600 civil investigations and a few hundred criminal investigations. Recoveries dropped for the past couple of years. In fiscal year 14, it was about $600 million. Last year, about $690 million, so nothing to shake a stick at. And there again, they've been running, kind of anywhere from 2,500 to nearly 4,000 civil investigations each year. So they've been very active, and their activities are bearing fruit and paying off in terms of having success recovering assets. So we would certainly expect that that level of activity continues. On the right-hand side, we have the IRS also running around out there enforcing. And these guys obviously are the tax guys. So their enforcement activities are similar, but they really look through a lens of making sure the plans are operating in compliance with tax law, in compliance with their legal plan documents, and looking at it through that lens, a little bit less of a fiduciary lens. What we're seeing from both is, again, they've been much more active in publishing what they're doing, and they've made it very clear that they hope that we all learn from that activity. So the department within the IRS that's really enforcing qualified plans is this employee plan group, and as you'll see, they're creating websites and they're doing kind of market research campaigns, which we'll touch on, to make their efforts more efficient and really kind of be better at zeroing in on where they think the issues are, raising those issues, honing them, and then ultimately publishing them. So I'll give you an example of what I mean by that. Several years back, they created this acronym LEASE organization, but it's Learn, Educate, Self-Correct, and Enforce. And what the IRS started doing was really kind of doing market research panels. Essentially, that sounds a little bit maybe hokey, but they're zeroing in and they'll do kind of these focus study groups on typically about 50 different plan sponsors, but they try to find groups that are similar in some fashion. So maybe businesses from a particular industry or businesses of a certain size. And the premise in them doing this was that similar groups probably have similar issues, and they wanted to dig into that and explore that. And in doing so, they thought that their investigators become better armed at what they should probably be looking for as they walk in to conduct an investigation, but then also starting to kind of put that message back out to those groups to learn more. So one example that we saw recently was they actually targeted plans, targeted a nice way to kind of do this focus group, on the very small end of the spectrum. So they looked at plans that had assets of roughly about $100,000 in plan assets up to about $250,000 in plan assets. And so, what do we think might be the challenges or the issues of these groups? And what they found, actually in hindsight, wasn't all that surprising, but smaller plans, which tend to belong to smaller businesses, really struggled with things like keeping their documents in compliance and keeping amendments up to date. They also struggled with kind of the administrative aspects of a plan. Bonding requirements were something that they found to be a challenge for that smaller end of the plan market. So it became interesting because they could, again, kind of tailor their enforcement, but also put that message back out there to say, hey, if you're a small plan, you probably belong to a smaller business, and oftentimes it's great that you have benefits, But plan documents are these big, bulky, lofty documents filled with legalese, and you may not have people who come to work every day with the sole hat of monitoring and managing benefits from kind of an HR capacity. So you might be ignoring some of those letters that you're getting in the mail about required amendments, but don't do that, or don't lose track of your fidelity bond and the minimum coverage requirements, because it's easy to kind of miss that stuff because it might seem like Greek, but clearly that's of great importance both for a plan sponsor, but certainly on the radar of a regulator. And so they're trying to learn from kind of these market research studies, for lack of a better description, that they've been doing out there. The other thing that we're seeing is they're doing kind of more compliance questionnaires or surveys. They started doing this back in 2010, and while many of you have probably received a questionnaire or survey in the mail and probably ignored it, people tend to not ignore those when they come from the IRS. So the response rate has been quite good through this exercise since they've been doing it for the past number of years. And here again, what they're doing, and we've included some links, is they're publishing that. And I would venture to say that many plan sponsors aren't out surfing the IRS and the Department of Labor websites, but in their mind, that's what they hope will happen one day. So these are big, bulky documents of their findings, but thankfully they also provide kind of the Cliffs Notes versions out there, and they're summarizing a lot of it to make it a little bit more focused into what might be those next focus points that are coming down the pike as they've learned from these surveys and these questionnaires. So what they've shared through their communication back to the public is that they're going to start looking at things like hardships. There's some concern on the regulator's behalf of our hardships being administered correctly. We're seeing also some shared insight around loans and the administrative requirements of loans. Roth, which has now been around for about 10 years, is getting more play in terms of greater usage, greater offering inside of qualified plans, and that seems to be something that they're indicating that they're going to start looking at going forward, is Roth being administered correctly in terms of the holding and the reporting as it relates to Roth. Top having excess contributions, we're going to touch on that throughout our time today, has always been a focal point of the regulators to make sure that plans are operating correctly in terms of the level of contribution from both employees and businesses. So there's a lot out there, and they're publishing more and more of that to allow us to learn from their activities. Pivoting a little bit, I wanted to get into getting, so what does that audit then look like? If they're trying to become better regulators, how can we better prepare ourselves as advisors, consultants, and plan sponsors to kind of deal for that thing that we hope never happens? Well, on the IRS side, what they've made clear is that the very first thing that they're going to look for and ask for is a plan document. That's how they're training their staff. When they reach out to a plan sponsor to conduct an investigation, that's absolutely the first thing that they look at. And as I mentioned from the outset, as kind of the tax guys, they want to make sure that plans are operating in compliance with tax code, but also with the terms of the plan document. And then as they collect that, as they dig into that, they've highlighted, we've highlighted on the screen here for you, things that they'll tend to then zero in on. How have you defined compensation? Are you operating in accordance with that definition? So for example, are you including overtime or bonus as part of the compensation for plan purposes? And are you calculating contributions correctly? Matching, are you matching to people that you said? Have you defined the match in your document? Are you operating in accordance there? Are you passing testing? Eligibility is something that they look at in terms of, are you offering the benefit to those who are eligible, or are you restricting those who aren't, which is just kind of that administrative oversight issue of somebody might lose track of that new hire and whether or not they should be offered or allowed access to the plan. Timeliness of deferrals we'll touch on, but that's been a real topic, and I'll get into later, kind of there's some confusion around what that defined period is of the 15th business day of the following month versus the kind of that gray area of doing it as soon as administratively feasible, and that kind of becoming your new timeline. Hardships and loans, I mentioned, is something that they're keeping an eye on. So to kind of pivot and give you a little bit of an example, this was actually a real case, an investigation from the IRS. There was a profit-sharing plan called Christie and Swan, and this was an investigation that happened back in 2011. Some of the background and the quick details as it relates to this, it was uncovered that the plan failed to restate for what we call the EGTRA, but the Economic Growth and Tax Relief Reconciliation Act, which for you qualified plan geeks was something that came around in 2001. So this was found 10 years later. Not only did this plan miss that required amendment, but they missed following interim amendments, and they chose not to correct through the IRS voluntary compliance system. So we'll talk about that here shortly, but the IRS actually does encourage people to correct issues voluntarily through a variety of different kind of online resolution programs, and we'll touch on that here shortly, but this plan chose not to. And the outcome was that the IRS disqualified much of the activity as it relates to the plan. So I'll give you a couple of details around that. So again, this happened in 2011, and it was determined they missed an amendment from 10 years prior to 2001. This plan, upon that being discovered by the IRS, was encouraged to correct the issue and essentially ignored that advice and said, you know what, IRS, thanks for the advice, but we're not going to follow you on that one. That didn't go over well with the IRS in this case. And so they disqualified activity actually going back to that first missed amendment. So they disqualified 10 years of activity on the plan, which becomes a really big deal. So now all contributions and activity made by the business as well as all contributions made by the employees become income that must be declared. So all of those pre-tax, pre-income contributions are null and void. So you have pretty hefty penalties, pretty hefty tax consequences over a 10-year period of time, which is something the IRS certainly has the right to do. Disqualification is not typical in these instances, but I think the regulators want to make it very clear that if we suggest that you fix something you probably should, and failure to take that advice typically doesn't end well. So what could they have done? As I mentioned, there are a number of correction programs that both IRS and DOL encourage. In this case, on the IRS side, there's really 3 that they try to promote and get used. It depends on kind of what the issue is and who found it. So the voluntary correction program is one. This will typically happen if the employer discovers that there's an issue inside of their plan. They want to get that fixed. They want to get back to having a clean slate. They can literally go out to their website, work through the system, and fix whatever that issue may be and deal with any fees or penalties that might be tied to that. But typically that outcome is going to be far better than the disqualification scenario that we saw with Christie and Swan. Kind of option 2 that you'll see out there is a program that they call audit cap. Similar to the voluntary correction program, difference here is if the IRS finds the issue, you go through audit cap. Penalties might be a little bit greater, but again, far less than the potential of disqualification. And then for minor issues, they will oftentimes encourage that an employer may on their own go through the self-correction program. This typically is more just operational issues. It's not that your document per se is out of compliance, but you may have unknowingly operated out of the terms of your document. So for example, eligibility or matching provisions, or there may have been some term of your document that you were mistakenly operating outside of, and you can go through the self-correction program there. And they actually become pretty easy processes to just go online, kind of work through that system, and get back to having that clean slate on the plan. Pivoting to DOL, as the fiduciary guys, they have kind of similar hot buttons, but again, we wanted to highlight what the Department of Labor is focusing on and looking at through the course of their activity. As the ERISA guys, obviously they're focusing on ERISA and plan documents, and they absolutely want to focus on whether or not the plan is being operated in the best interest and the exclusive benefit of participants and beneficiaries. They're looking at things like, are assets being held properly and valued properly? Are you following the terms of your plan? Are you documenting and properly going through a process of selecting and monitoring your service providers? And is the plan not being used to benefit parties of interest in the plan sponsor? And so we'll get into some more detail around that as well. Like the IRS, the Department of Labor has created a number of kind of quick and easy online quick fix solution programs, one example being the delinquent filer voluntary compliance program. So this is something that's often used if plans are delinquent in filing their 5500. They can work through that process to get back on track there. And then they have correction programs for where they're seeing a lot of issues. So we've highlighted some of those on the screen. Big focus, as I mentioned earlier, on the timeliness of remitting participant contributions or the timeliness of remitting loan repayments. Were fees improperly paid from plan assets that shouldn't have been? Was compensation, as I alluded to earlier, not being defined correctly or followed according to the definition? Improper bonding. So a lot of those kind of administrative type issues can be corrected right through their correction programs that are on their website as well. And here again, I wanted to walk you through kind of a quick case study. This is actually a hypothetical study, but kind of put some color around where the Department of Labor is focusing and also how you would fix an issue. So here we have a hypothetical company, Company A. They have biweekly pay periods, so they're paying every other Friday. Deferrals are consistently, in this example, $25,000. Based on their past history, they've shown that deferrals can be segregated from plan assets and remitted 10 business days following each pay period. And so there's a pay period on March 6th of 2012. And based on their history, that should have been remitted on March 20th. And I'll get to some of these details and why they matter shortly. In this case, they actually remitted payroll on May 18th. Now, in 2014, they kind of discovered, hey, we were late, we should probably do something about that, and they go through the voluntary correction program through the DOL. And this is what that looks like. We show you this because it really becomes pretty easy for plan sponsors to follow and comply with these things. So there's a screenshot of the DOL website and the calculator, and they input a lot of the information that I just ran through. So the payroll being $25,000, the loss date was on March 20th. They then funded on May 18th, and they're going through, or they realized this, March 14th of 2014. So they input all of that data. The DOL then spits out a figure and says, okay, you have to contribute $127.99 to the plan. So in this case, plan sponsors will sometimes look at this hypothetical example and say, well, it's kind of a tiny little amount. That's not a big deal. In reality, if they were late on one, they may have been late on several, and that could become a bigger number. But the takeaway is that this becomes a pretty easy solution to get your plan back on track and get back to that clean state period. And that's exactly what they want, is they want to make this easy. They want to kind of get things going again. And so they're promoting programs like this for plan sponsors that find these issues. One thing that I think will probably maybe come up in Q&A, but I'd like to mention because this is where we're seeing a lot of kind of the headlines and the regulatory activity and some of the lawsuits that we're seeing out there are very much around fees. In the new fiduciary rule that was published a couple of weeks ago, lots of talk around fee in that new rule. In 2012, we saw 408B2 and 404A5. So I like to really recommend, too, as we start to get in a little bit here around how do we then use this and put this into action around processes and procedures, paying attention to fees is not something that's going away, and it's only going to become greater. The regulators, I think, realize that they need to maybe improve how that message is transmitted to plan sponsors and how those disclosures are formatted. But that is of utmost importance as plan sponsors start to assess the reasonableness of the fees that they're paying for the plan, and also that spills into selecting and monitoring service providers, and we'll touch on that here shortly as well. Briefly, and for time's sake, I won't go into too much detail here, but you're also seeing this play out in the courts. There's been a number of suits in the headlines over the past several years, but there's interesting takeaways from each. So we saw a case, Tussey ABB, very much centered in fees, but one of several things that came out of that that was of interest is it brought to light their use of an investment policy statement and their ability to follow that. So quickly, this plan went through a conversion of service providers. They changed record keepers. In doing so, they also changed the target date suite of funds that the plan was offering. And while it was great that they had an investment policy statement, when they made that change to their target date funds, they did not do so in compliance with their investment policy statement. So it's been ruled that it's great that plans have this, but when you create an investment policy statement, the courts have ruled that that is a plan document, and that document must be followed. So we're seeing, little details come out of lots of details in these suits, which are shining light on some of these things that plan sponsors may not have been aware of. They might have thought, I'm doing a great job because I created an IPS, but in doing so, you really need to make sure that those are being followed. So that's bringing more light to how are we structuring those documents? Are we creating them in a way that makes it possible, if not easy, for us to follow the terms of those documents? Other headlines that were out there just recently, Tibble versus Edison, which raised into question the statute of limitations on things like investment reviews and selection process. Dunehofer versus Fifth Third Bank was a suit that's looking at company stock and whether an employer should restrict the access of company stock if they're privy to information that might result in there being some pressure on stock, which is then raising questions of if they were to restrict ongoing purchase, is that being done on inside information? So it's really opening up some interesting cans as we see some of these lawsuits, but there is no shortage of them happening. So we're trying to learn from those that are happening so that we can improve our processes. So where do we go? What the regulators have made clear and what they're publishing and what we've incorporated here is you start to build in a process of some checks and balances. Whether you're working with plan sponsors or whether you are a plan sponsor, it just becomes starting to build in that process of reviewing certain aspects of your plan and working with your service providers to help with that process. And we've highlighted some of those here. So, for example, plan document checklist, because we know the regulators are looking and it's the first thing the IRS asks for. Do you have a copy of your original document? Do you have up-to-date and current amendments as it relates to that document? If you had submitted for an approval or an opinion letter, do you have accompanying copies of that? As you perhaps make amendments to your plan, are you keeping resolutions of board meetings and documentation around having decided to make some of the amendments to that plan? That extends to summary plan descriptions as well. So while it seems maybe simple, it's nice to kind of go through that exercise so that you know that your housekeeping is in order and things are current and up to date so that you avoid issues that we've seen other plans experience. Operationally, as I mentioned, both regulators are looking to see whether plans are operating in compliance with their document. So looking at something like the definition of compensation, how have you defined it? Is that actually what you're operating under? So the example I give is, are you including or excluding things like bonuses or overtime? Were matching contributions made appropriately? Are you passing your discrimination testing? Have you extended the benefit to eligible employees and not ineligible employees? Are you correctly administering loans and hardship distributions? Internally, what we would encourage is plan sponsors periodically spot check their plan. So compare what are you remitting to your service providers as it relates to compensation. Is that how you've defined it? Checking things like dates of hire and service as it relates to determining eligibility and vesting. Have you verified marital status, which has an impact on processing distributions? Are you ensuring that participants that need to take them are taking required minimum distributions? So that's an easy spot check audit that we would encourage plan sponsors to go through. And then as it relates to service providers, the Department of Labor is looking at that fiduciary process. Are you doing things in the best interest of plan participants and beneficiaries? So can you assess whether the services from a particular service provider are necessary for the plan? Are the fees, which I mentioned is a huge focus point right now, are the fees reasonable for the services rendered? Have you documented that process of why did you select your provider? And are you doing things like benchmarking the services that you're receiving? If your providers are required to be licensed, are they? And are they delivering what it is that they promised to deliver at the outset of that relationship or through a service agreement or contract? So easy to kind of walk through that, but doing this becomes creating a process, ideally documenting that process, because the end result is just a plan that's in much better shape, and should the regulator knock on your door one day, housekeeping is well in order and in good shape as well. And that can be a bit daunting for an employer, so when we present this to employers, we like to remind them as well that there's a lot of resources out there take advantage of advisors and consultants, and this is how advisors and consultants can position themselves as well to help through that process. Help plan sponsors understand their fiduciary responsibilities and help them understand what's going on out there from a regulatory perspective. Third-party administrators, record keepers can also help with much of this. So employers and plan sponsors are not on their own. Those services might come from other parties, CPAs and attorneys. Investment companies oftentimes offer resources and support to help plan sponsors and help consultants and advisors navigate these waters as well. And then design a strategy. We stress that employers, again, learn from what's going on out there. And I mentioned it earlier, I'm willing to bet that most plan sponsors aren't actively surfing the Department of Labor and IRS websites, but there is a lot of information out there. And here again, leverage service providers to help bring this to the forefront as well. But starting to create a strategy is what we hope folks will accomplish at the end of the day, and work through that and start to create some habits around spot checking and doing self-audits of your plan and evaluating and documenting your activity. So I've thrown a lot at you, but I am at about my half hour, and with that, I guess we can open it up to, or through the chat function, any Q&A that might be out there.
Yeah, thanks, Rob. We'll open that up to questions, so please feel free to enter those in the GoToWebinar questions panel there. And just wanted to reiterate what Rob closed with. While Epic, as your record keeper and/or administrator, will certainly do everything we can do to keep all of your plans out of trouble, it's really good to know this stuff, to really be an expert on what the DOL and IRS are looking for, so that even in your sales efforts, client retention efforts, you can go out there and promote yourself as an expert and really helping them navigate through what can be complicated waters. So it may seem simple to us, but this is all very overwhelming for the average plan sponsor, as I'm sure you're aware. But with that, we've had a couple of questions roll in. Rob, first and foremost, I could see how some of these voluntary correction programs might seem as almost incriminating oneself. Do you have any approaches to get over that hurdle with a sponsor? And is it really always in the best interest of a sponsor to go through the voluntary correction when they know something's wrong? Do you have any general thoughts on that?
Generally, I would say it is. As far as worries about it becoming incriminating, that's not been what history has shown. So it's the regulators in virtually everything that they've published and said, and based on their activities, really prefer that method. The plans can go on and without fear of an auditor then knocking on their door, clean up whatever issue there may be and get back to having a clean slate and moving forward. I also, and I didn't mention it earlier, but when I rattled off kind of those stats of where the DOL's recovered assets and the number of investigations, they also published that about 2/3 of the assets that they recovered started from a complaint from an employee or a participant. So in that sense, too, I think that if a business owner is aware of an issue in a plan, going through a voluntary correction program is far better, and actually their systems will even say cheaper than having that uncovered by a regulator and still going through the correction program, but at that point they found it versus you. So doing it on your own
Right.
typically is better and cheaper.
Makes sense. It seems as though, of course, we're going to continue to see an emphasis on the things you mentioned, even in light of new fiduciary roles that are getting all of the press today. Do you see any impact on these areas of focus that you mentioned today in light of new rules coming out over the next year, or being with enforcement starting next year as far as a resource perspective and a focus perspective?
Yeah, from a resource perspective, I think that remains to be seen. So we're all digesting the new fiduciary proposal, which in its final stage, while better than the proposed stage, potentially brings huge changes to the industry. So how the regulators allocate resources remains to be seen. I think in terms of many of the items that we covered today, I think the importance of them post-DOL fiduciary rule becomes that much greater. I think advisors and consultants are going to be held to a higher standard. In many cases, advisors and consultants, as a result of the new fiduciary rule, will themselves be fiduciaries to plans, which isn't always the case today. So I believe that there will be a greater need and demand on the part of all of us as service providers to plan sponsors to help with these processes. So we hope and expect that the outcome is that more and more plans will start to build a process. Because while some of this can seem a bit scary, ultimately I think much of it's easily avoidable through kind of some of those checklist type activities and those checks and balances, and start to incorporate a process, document your process, and that goes a tremendously long way in avoiding issues. But again, I think the demands on service providers, particularly advisors and consultants, will be much greater post-fiduciary rule.
Good stuff. Well, thanks again, Rob, and to the OppenheimerFunds team, and thanks to all of you for joining this session of Epic Insight. We appreciate your partnership and look forward to seeing everyone at a future session. Have a great afternoon.